afternoon, and good morning to those of you on the West Coast. My name is Heather Engel, and I'm the Associate Vice President for Gift Planning here at the University of Virginia. I am pleased to welcome you to our Spring Estate Planning 101 webinar. Here are a few housekeeping items. First of all, this session is being recorded. In a few days, you will receive an email with a link to the recording. Closed captioning is also available. To submit questions during the session, use the Q&A feature. We will address as many questions as we can at the conclusion of the presentation, including those submitted online during the registration. Steve was also kind enough to review your questions prior to putting his presentation together, so a number of the questions are already answered in the presentation. Please note that we are not able to answer questions about specific individual situations or particularly complex matters. And now I would like to invite Steve to turn his camera on for our introduction. I am pleased to introduce our speaker, Steve Murphy. Steve is the co-chair of McGuireWoods Private Wealth Service Group. He helps clients develop and administer thoughtful estate plans. He advises executors and trustees in administering complex estates and trusts. He is a frequent author and speaker. Perhaps, however, most importantly, he is a lecturer at UVA's School of Law, where he teaches trust and estate administration and estate planning principles and practices. Steve received his JD and PhD from UVA, where he was an editor of the Virginia Law Review and received the Ritter Award for Honor, Character, and Integrity. Steve is licensed to practice law in Virginia and Washington, D.C. We are delighted that Steve has agreed to share his expertise and his enthusiasm with us today. With that, I turn it over to you, Steve.
Thanks so much, Heather. I'm going to open up the presentation now, share my screen. It's such a pleasure to be here, and thank you, Heather and Elizabeth Hillis and the rest of the team at UVA for having me join. As Heather mentioned, I have the real distinct privilege and pleasure of living here and working here in Charlottesville. I've turned my camera, but looking out this window, you can see downtown Charlottesville. Changed quite a bit since many of you graduated. And actually, if you really squint, you can actually see the very top of the rotunda. So it's a really great view here. But I also happen to practice and work with clients all over the country. I give presentations and seminars and also advise individuals and fiduciaries on some of these complex matters all over the country and also right here in Charlottesville and Virginia. As Heather mentioned, one of the really enjoyable parts of my day is I teach 2 courses at UVA Law School. And I really enjoy having these conversations with students about some of these issues and also educating my clients. But I have to, before I start this presentation, I have to give a real special thanks to Skip Fox. Skip has given this presentation previously. He was a really tremendous professor of mine, and then boss and colleague and mentor and partner. He's now retired. We still see Skip a lot. He's working on various boards, and I think he and his wife Beth are really enjoying their retirement. So I just want to especially thank Skip, and he also prepared some of these materials that we tend to use in some of these presentations. So this presentation is called Estate Planning 101, and what we're really going to do here is try to just cover some broad issues to consider in your own estate plan. And over the next hour or so, we'll talk through a lot of these issues. A number of you had some very interesting questions that we'll try to address. But as a starting point, we might just ask the question, what do we really mean by estate planning? Well, I actually have a very broad definition of what that means. We're going to talk about wills, we'll talk about trust and the like, but we're going to take a big step back and think about a much broader definition. And that is really just planning for the transfer of assets upon death and during life, and making sure those assets are used the way that you intend. We're going to talk about minimizing taxes. We're going to talk about protecting assets from creditors, providing rules and standards for the use of the funds. But again, really broadly speaking, it's all about making sure that the funds are used the way that you would intend. Now, I have to start by making one comment about a podcast that I've just launched. I found that in giving these presentations, I just don't have the time to go into a lot of detail about some of these particular techniques, but also about some of these broader issues you should consider. So I have this podcast, I call it Once Removed. And I came up with that title actually when discussing with some other professors at UVA Law School. I called it Once Removed because that phrase once removed helps to suggest family, right? Like a cousin once removed. But that phrase also, brings to mind this idea, how should your assets be administered once you're removed from the equation, once you pass away, or perhaps once you make a gift? What's the best structure to use to make sure those assets are used the way that you would intend, once you're out of the picture? So you can check out that podcast where I explore some of these in more detail. All right, so first, it's sort of thinking through a couple of key documents that we'll discuss today. First, maybe a group of documents that you would have that would address planning during life and during your incapacity. One's called a property or a financial power of attorney. That's where someone is named to handle financial and property matters on your behalf, such as if you cannot. The second is a healthcare power of attorney. That's where you name an individual to make healthcare decisions on your behalf if you're not able to, including that infamous sort of pull the plug decision. And then another document sometimes called a living will. That's where you might express your wishes of what kinds of care you would or would not want to receive if you're not able to make those decisions for yourself. In Virginia and some other states, we call these by a different name. We combine them in Virginia into something called an advanced medical directive. In your own individual states, you might have separate types of forms or documents to carry out, especially these types of wishes if you're disabled. The next document to think about only applies upon your death, and that's your will or your last will and testament, and we'll talk about that in more detail. And then lastly, another document that we often use in our planning is called a revocable trust agreement or a living trust. And we'll talk especially about how that can be used to minimize probate, avoid probate, simplify administration, and provide some other benefits for your assets during your lifetime and upon your death. So with that terminology in mind, I want to just sort of change the subject entirely and just talk about how assets are transferred during life and upon death. And I'm going to talk about 4 different buckets. I feel like this is a helpful way to begin this discussion. The first bucket would be assets that are governed by a beneficiary designation. An example of this might be life insurance, a retirement account, a 401k, an annuity. So as many of you know, when you open up that type of account, you fill out a blank on a form, or these days, you just sort of click in a few things, maybe click some radio buttons online, and it names a beneficiary of who receives those funds upon your death. So if you have a life insurance policy, you might name your surviving spouse as the beneficiary. Upon your death, the surviving spouse would contact the life insurance company, would provide them some information, and life insurance company essentially sends them a check. It really can be almost that easy. And notice that I haven't mentioned an executor, haven't mentioned a trustee, haven't mentioned probate. So that's bucket 1, assets that might be governed by a beneficiary designation. The second bucket are assets that are owned by you individually, but are owned jointly with someone with survivorship. An example of this is a home. It's very common for married couples to own their home jointly with survivorship. In Virginia, we have a particular way of owning property called tenants by the entireties. And that's magic language. It means the spouses own it jointly with survivorship. Upon death, the deceased owner's interest essentially just disappears, and the other owner just becomes the owner. Sometimes there are some forms you can file, maybe with the court, to confirm that transfer. But again, it really can be that easy. And notice I haven't mentioned an executor, haven't mentioned a trustee, haven't mentioned probate. The third bucket, we're starting to get into some other vehicles, and the third bucket might be anything that's held in a trust. And an example of that might be the revocable trust that I just mentioned. You could set up a revocable trust. You could also set up an irrevocable trust during life. We'll talk about a couple of reasons you might do that. If assets are owned in that trust or are payable to that trust upon death, well, the trust itself doesn't die. but upon the settlor's death, maybe just a new trustee takes over and administers those assets according to those terms. There's some advantages here. The trust agreement is a private document, doesn't have to be filed with the court usually. Also can be a lot simpler to administer without accountings and the like that you might need for a will. And many clients find it very helpful to gather all their assets in the revocable trust during life and upon death to provide that one vehicle for holding all of their assets. Now, one comment I'll just have is there are a lot of questions that came in asking at what level of assets might it be helpful to have a revocable trust, to use a trust in your planning. We're going to unpack that a little bit over the next few minutes, but just one initial comment is we have to be careful about what kind of trust we're talking about. If you're talking about using a revocable living trust in your planning, well, the goal really here is simplicity and privacy. I think at almost any level of assets, it would be a good idea to think about having a revocable living trust. A separate question would be whether those assets should pass into ongoing irrevocable trusts upon your death. We're going to get to that a little bit later, but I just wanted to flag that one question that many of you had at this point. All right, now we're to the fourth bucket. So if you think about the other three buckets, I didn't mention executor, only mentioned trustee once. But the key about all those other three buckets is that there was some provision already. Maybe it's in a contract, maybe it's in the deed that tells us who's the owner upon the person's death. Well, what about assets that don't fit in those categories? Those are assets in your individual name, without a joint owner, without a beneficiary. Well, if you think about it, it's not clear who the next owner's supposed to be. Maybe it's something like my checking account. Maybe it's in my individual name without a joint owner. It's not really clear who owns those funds upon my death. So we need some form as a society to tell us who the next owner is going to be. And that's a process called probate. It's supervised by the court. There are usually various reports and accountings required. Now, the terms of that, of who would actually receive those assets, are usually found in a last will and testament and codicils to that last will and testament. If you don't have a last will and testament, then the funds still would pass under to your beneficiaries, but under a different set of rules called intestacy. And we'll talk about that in a little more detail. The person who oversees the estate is called the personal representative. That's the executor, or if there is no will, it's an administrator, and different states have slightly different terms for that. But again, typically, probate requires some formal oversight, requires some reporting to the court, like inventories and accountings. Sometimes requires court permission to make distributions or the like. Now, we tend to try to minimize or avoid probate when possible. That being said, the probate process can really be managed in an effective way. Some people tell these sort of nightmare stories of how probate could take years and years and be sort of endlessly complicated. Hopefully that wouldn't be or won't be your experience. But again, we still find it helpful to avoid or minimize probate whenever possible. So those are those four sort of buckets to think about as you structure your estate plan. Again, a lot of what we'll talk about is how those assets pass and then how that might affect your overall plan. All right, so now shifting a little bit to talk about some of these key documents. If you don't have a will, then the assets actually pass through these default rules that are set by law. And I'll just give you the example of what happened in Virginia. In Virginia, if you don't have a will, then those individual assets would pass through your estate and would go, if you're unmarried, it just goes to your descendants. If you're married but don't have any descendants, it goes to your spouse. And then if you're married with descendants, maybe in some combination of your spouse and descendants. And if you don't have any of those, it essentially goes back up the family tree to your more remote descendants. I like to pause and just make a comment here about intestacy, because some people are concerned that if they don't have a will, then their assets will go to the state or will go to some sort of long lost heirs. That's really not the case. Instead, those assets would pass under these default rules set by the government. So one initial question, when someone asks me if they need an estate plan, I say, well, you already have an estate plan. It's just that estate plan is probably governed by things like beneficiary designations and joint ownership and intestacy. So the real question you're asking is, should I also have a will or a revocable trust? So if you want to put some more planning in place, you don't like those default rules, then you could have a last will and testament. I think it is a great idea to have a last will and testament. We often think of a starting point as a very simple will. The simple will would just pass assets to your beneficiaries outright. We also sometimes talk about something called a sweetheart will. A sweetheart will would be for married couples, maybe leave everything to the spouse if the spouse survives. And if the other spouse doesn't survive, then it all goes to your children, again, maybe outright. Very simple starting point, very simple structure, but it still would require the opening of probate and assets to go through probate. Another thing a will can do is to name guardians for any minor children. So when I get this question about whether someone should have an estate plan, should have a will, one question I often ask is, well, do you have minor children? If so, then it might be a very good idea to have a will in place so that you can determine who are going to be those guardians for those minor children. In fact, that might be a good starting point. Just as I start working with some clients, we might put in place a very basic structure to at least name guardians for their minor children. I like to comment to clients that, it would be a good problem to have if there are so many potential guardians that lots of people would love to raise your children if you pass away. But that also sets up a problem because there might be some dispute and some tension. So the real best person to make that decision would be you, and you could put that in your last will and testament. You could also have a more complicated will. Sometimes we call this a complex will as opposed to a simple will. Sometimes this wouldn't just pass assets outright, but would incorporate some ongoing irrevocable trusts that would manage assets for other time periods. And we'll get into some more detail about how those trusts might operate. You could also have a will that incorporates some tax planning and some non-tax planning. Again, we'll talk about some of those different strategies a little bit later during the presentation. So another question that came in was, at what point does it make sense to start using these more complex vehicles? And we'll get into that in a little more detail because it's really not a question of the amount of money or the complexity or taxes. It really has to do with what's your overall goal, and then what's the best tool to help you reach that goal. Now, before we get to trust, we want to think about how to connect the dots. If you use a revocable trust, then you would still have a will, but it would be a little simpler will called a pour-over will. Now, remember those buckets. If we have a situation where you do have a bucket of the revocable trust, well, you might still have some assets that are in your individual name without a joint owner, without a beneficiary, and not in the name of the revocable trust. Those assets would still go through probate. So this pour-over will would function in order to step into that breach and really just name one beneficiary. And that one beneficiary of your estate would be the revocable trust. So it pours those assets from the estate over to that revocable trust where they're then administered. This helps to minimize probate and that probate process. So again, coming back to this idea of these buckets of assets and how assets pass at death, we often think of the will as the most important piece of the estate plan, sort of like the cornerstone or the linchpin. But actually, as we've been discussing, it really isn't the most important. In fact, it almost acts like a backstop, or almost acts to clean up any other provisions that any other assets that aren't governed by other designations. So again, thinking about the will, it's certainly important to have a good thought out will, but we also want to coordinate the will with all the other beneficiary designations and joint ownership and the like that you might have in your estate plan. All right, and now we're to another important document in your estate plan. We call this the revocable trust. So again, we're talking mostly about how assets pass, just the mechanics of that succession. Do they pass under the estate, through your will, or do they pass through the trust agreement, through this revocable trust? And there are some really important differences between passing assets under a will and through probate and under the revocable trust. One, which I think is very important for a lot of the clients that I work with, is privacy. The will is typically a public document. It'd be recorded in the courthouse. So if your will names all your beneficiaries, then people will know. What are the terms of those bequests? Who did you include in the will? Who did you exclude from the will? How much money are they going to receive? If there are terms of trusts, or if there are trusts, when will those trusts terminate? When will that child of yours receive an inheritance outright? Those could be issues that you want to keep private. If you have them in a revocable trust, then they're typically private and won't have to be filed in the courthouse. Meanwhile, a will typically does become a public document upon death. Another important element of privacy has to do with the amount of the assets. I mentioned that the probate process is supervised by the court, and there are various filings like an inventory and an accounting. Well, that also means that in many jurisdictions, a third party can actually look up and find out how much money passed through your estate. So if you're concerned about privacy of actually how much money passes through your estate, not just how it passes through the estate, then you'd also want to use a revocable trust to completely avoid probate. You can imagine if someone looks up and finds a pour-over will, they might not know very much at all about the person's estate plan. Meanwhile, they might not know anything about the assets if the assets have passed directly to the revocable trust. So again, keep that privacy concern in mind. Now, a couple of other elements, which again, I think privacy is really far and away the most important thing to use here for a revocable trust. Using a revocable trust can help to lower or control administration expenses. It can be harder to challenge than a will, or a little more complicated to challenge than a will. But then importantly, the revocable trust does not save federal or state income tax or estate tax. This is a question I get a lot, of setting up a revocable trust with the hopes of maybe minimizing estate tax or managing income tax. And I can very confidently tell you a revocable trust makes no difference in terms of federal estate tax that might be due upon your death, and makes no difference of income tax due during your lifetime. The estate tax code and the income tax code would treat those revocable trust assets as if they are your own assets. So again, it's not a tax savings plan to use the revocable trust. It's something different. It's about ease of administration. It's about privacy. And the last bullet here, the revocable trust can also help manage assets if the settlor is disabled. So you can have some lifetime planning also. So I've talked about, all the sort of background of how assets pass upon death. And then what are some key documents, the will, pour-over will perhaps, and a revocable trust. Sometimes clients are so focused on those issues that they forget to ask these bigger questions. And this is actually why I launched the podcast, because I find myself really pressuring clients to think more and more about these broader questions. Some clients are so focused on things like avoiding probate that they're not focused on other questions, like some of these here on this screen. Number one, who should be named to actually manage the funds upon your death or in the event of your incapacity? We're going to talk a little bit later about disability planning. You want to make sure you name the right agents for your finances and for your healthcare. And then upon your death, who's going to wind up your affairs? That's usually the executor and the trustee. Or if you have a long-term trust, who's going to manage that over time? Again, we can use other vehicles to avoid probate, simplify administration, but the real key is these broader, I call them strategic questions. And one other thing that's great about these questions is that the really best person to answer these questions is you, is a client. And there's no right or wrong answer. It's really about what's the best vehicle to serve your goals. So then we also ask maybe what? What is this structure going to look like? If you're married, if you have descendants, if you have other beneficiaries or charities, who should receive those funds? In what kinds of shares? And we'll talk a little bit more about maybe how to balance different shares among your different beneficiaries. But you could have individuals receiving bequests or shares, to a spouse, to descendants, to grandchildren, other individuals, and even to charities. We're going to keep going with these questions. Next question might be how? Do they receive those funds outright, or do they receive those funds in trust? That's a complex question. And again, it's a question that requires some real thought. It's not just about maybe avoiding some expense or simplifying a structure. Again, it's about what's your overall goal. And we'll talk about some advantages and disadvantages of trusts in a few minutes. But then one important structural question will be, upon your death, do those assets pass outright, or do they pass in some kind of ongoing trust for that individual's benefit? And then why? Some clients start talking to me about these planning, and I almost seem like the stick in the mud, because I keep asking, well, why are we doing this? Why do you want to have certain assets passed to charity, certain assets passed to individuals, in trust or outright? Again, let's really think about the goal. Some clients are really concerned about tax planning. That's a legitimate goal, but I think that probably shouldn't be the most important factor, and it certainly shouldn't be the only factor. Another reason to consider assets passing in trust or outright might be asset protection planning. We'll get to that in a little more detail a little bit later. And then maybe the last question would be, what about when? When should some of these transfers take place? And I feel the need to emphasize that now, because a lot of clients come to me and they're really anxious to start making gifts now. Maybe their financial advisor has spoken to them about some potential tax savings years from now if they make gifts now. So they almost come to me really with this emphasis and focus on making gifts now. And I really feel like that's putting the cart before the horse. Instead, I want to take a big step back and think, okay, hold on. What's your goal for this property upon your death? And then if it makes sense, then we can explore maybe making some gifts during life. Maybe that will have some tax savings. Maybe that will have some asset protection savings, or maybe some other benefits. So again, it's all about identifying the overall goal and then thinking, how do these different pieces or tools help to address that goal? And so here's some more sort of comments about why you might make transfers during life. I talked about tax planning and asset protection planning. I have to give a shout out to one professor at UVA named Alex Johnson. He's written some articles on one benefit of making gifts now, which I love it. He calls it a pre-commitment strategy. The idea being that, maybe it will or won't save estate tax in the future to make a transfer, or income or tax now or in the future to make a transfer. But maybe you're just committed to making this transfer now. Maybe you don't just want to earmark some funds for a grandchild. You want to make that gift now, even if you might change your mind later. Maybe called a pre-commitment strategy. Again, thinking about all these things, you want to talk to your advisors about when you might want to make some of these transfers. All right, so with all that, now might be a time to think about some reasons you might want to use a trust, an ongoing trust as part of your estate plan. So I like to talk a lot about a spectrum or spectra. So there's really two ends of the spectrum of how to transfer assets to someone, either upon your death or during life. One end of the spectrum is to transfer those assets outright. As an example, if you have a surviving spouse, the assets might pass that surviving spouse outright. That is simple, that's efficient. And in fact, maybe you could even use beneficiary designations and joint ownership to avoid or minimize probate or any other administrative steps. But once those funds are in that person's hands, it's that person's funds for all purposes. It's almost simple to a fault, because now if that person wants to take all those funds and blow them, they can. If they have a creditor, then those creditors could seize that person's property. Or upon their death, they could leave the assets in a way that you maybe didn't intend. So the other end of the spectrum would be to leave assets in an irrevocable trust for the benefit of that individual. And there are various benefits of using trust. Now, I should pause here, and I comment to a lot of my clients. I'm not in the business of selling trusts. I'm not a trust salesman. I do talk about various advantages of using trusts, but only so clients can consider them. Plenty of clients decide to just pass assets outright to their beneficiaries during life or upon death. And I think that's a completely reasonable conclusion to come to. However, there are these potential advantages that I think you should consider the use of trusts. One might be this first bullet, to maintain an element of control over the assets after the transfer. You can designate the circumstances under which the beneficiary receives the property. Again, if those funds go outright to that individual, then the individual can use those funds however he or she would want. Well, and I'm going to unpack that. During that person's lifetime, you might want to have some measure of control over when those funds are used. You might not want them to just be able to spend the money however they would want. You might prefer that the funds be set aside for education, or for retirement, or for other investment purposes, or for other beneficiaries. And then a second element of when the beneficiary receives property is you also might want to have some control over who receives the funds in the future. Who would receive those funds upon that beneficiary's death? Again, if you leave the funds to that individual outright, then he or she can decide, and that person might benefit a spouse, descendants, others, or charities. But if you use a trust, you could provide a structure that provides who receives those funds at that individual's death. You could also determine who will manage the property. Who's actually going to manage the property during that person's lifetime? We're going to unpack this a little bit as we talk about the control of a trust. But you can name a third party to manage the investments or to manage the trust. Again, so that someone else is making the decisions about how the funds are used. This next bullet point is a really important one. It's creditor protection. And clients are often very interested in making use of this. If you leave assets outright to an individual, and that individual has creditors, like hit someone with their car or defaults on a loan, or in some cases, maybe even a divorcing spouse, that creditor can seize that person's individual assets. But if you have left those assets in an irrevocable trust, as long as it has certain language, then for the most part, those assets are protected from their creditors. That is a tremendous benefit that you could provide to your beneficiaries. But importantly, you would have to make that decision to put the assets in that trust. Once an individual receives assets outright, it doesn't work, or it's not as simple for them to put assets into a trust for their own benefit and expect to have that same type of protection. And perhaps some other benefits of using trusts: you could protect children for a period of time if they haven't matured. You could even, provide some incentives for them to work in certain ways or have certain behavior. There are ways to use trust to minimize estate tax, and we'll talk about that a little bit later. But you also might want to consider the income tax implications of this. We're getting into some more specifics. I wanted to flag these as potential issues to consider setting up trusts, but we just won't have the time to cover all these issues in our presentation. So when I talk about trust, I talk about sort of three prongs. And the first is access. And what we're really talking about here is who gets to benefit from this trust. But I don't want to use the word benefit, because benefit is almost like using a term to define itself, because we talk about beneficiaries. What we're really talking about here is access. When will these beneficiaries receive the funds? You really could have two broad categories of distributions. One is mandatory distributions. You could require the trust to distribute the income on a regular basis. You could require distributions of fractions at certain ages, or at certain events like a marriage or graduation from college or graduate school. But you could also have those distributions in the trustee's discretion. And we often have language like health, education, maintenance, and support. And what that does is gives the trustee a sort of an ascertainable, more fixed standard of when they would make a distribution and when they would not. You could also give the trustee much broader discretion. We call that best interests. Now, the last bullet here is about rules versus standards. I really encourage clients to think about, what do they prefer? Do they prefer a trust that is based on rules that they feel like will be very fixed and will need to be followed? Well, there's some benefits to that. The one benefit is certainty. Maybe allows the beneficiary to plan if they know they're going to receive certain funds at certain ages or certain benchmarks. But there also may be some problems to that. Now the assets go outright to that beneficiary. Even if he or she has a creditor, it might lose those funds. The other end of the spectrum might be more of a standard-based approach, where you give a lot of discretion to the trustee, and then the trustee has the ultimate decision of whether to make a distribution. I think these days in our industry, we're really shifting a lot more towards putting in standards into trusts, where you name the right person as trustee, and then at the appropriate times, that trustee decides, should they make distributions to that beneficiary in accordance with your wishes. And importantly, if they think it'll have some negative effects, they can decide to not make distributions. We also think about the control. Who's going to actually control these funds? And that's really the trustee. When I think about who to name as a trustee, I really think about this nice Venn diagram. You could think about one group of trustees I refer to as a professional trustee. That could be a bank, could be a trust company. Historically, you could also name an attorney or an accountant. I tend to think that an attorney or accountant these days is probably not the best person to name, absent some other factors, just because of the way our practices and our sort of schedules are built. And banks and trust companies have gotten much more efficient administering trusts. That being said, if you really value the relationship of maybe the person who drafted the trust, your attorney could be an option to name as that trustee. Now, there's some advantages of naming a professional trustee. That person knows how to follow deadlines, knows how to follow rules. It's going to be, pretty impartial, at least viewed impartial by the beneficiaries. but it does tend to come with some expense. You could also name a family or a friend as a trustee. You might think about that, trusted friend or that uncle or that aunt. But importantly, this office of trustee is not an honorary position. It's not someone that you name just because they're sort of your best friend or they know your family well. This is an important position that comes with it a lot of responsibility and could even come with it liability. So you want to make sure you're naming the right person. Now, maybe the furthest end of the spectrum here of naming the trustee is you could even name the beneficiary as trustee. And the advantage here is that beneficiary who's going to receive distributions is the one who's actually deciding for investments and deciding whether and when to make distributions. That has some advantages, so maybe aligning everyone's incentives of how the trust is operated. And you can even still have the trust have the same types of asset protection and estate tax savings that you would otherwise have with a third-party trustee. The problem with naming a beneficiary as trustee, though, is that if you name the beneficiary as trustee, then the trust assets are essentially protected from everyone except the beneficiary trustee himself or herself. That is, if they decide to blow all the funds, it's very hard to stop them. So again, consider who best to name. You could also have co-trustee provisions, maybe have some checks and balances. And you could also put in some language of giving someone the power to remove and replace trustees. Now, one comment that I want to go through really quickly, just in the interest of time, is how about flexibility? If you have this irrevocable trust, how are we going to build in some flexibility? These days, flexibility is really important to include in trust documents. These are irrevocable documents that technically can't be changed, and they could last for generations. Well, maybe it's helpful to build in some flexibility. And there we call that what's called a power of appointment, where you might give a beneficiary the time or the power during life or upon death to transfer assets to someone else. Maybe they have the power upon death to apportion assets among their descendants. Maybe they have the power upon death to terminate the trust and have assets go outright. But importantly, this power holder is not a fiduciary. They can exercise this power for any reason or no reason. So you might consider some restrictions here. I see a lot of clients who want to make sure that assets stay within their family line. So they might structure the power of appointment to require the assets to nevertheless stay within their family line. Or they might want to give flexibility to those beneficiaries, like allow them to benefit a spouse or to benefit charities. Now we're going to shift a little bit and talk about some of these other documents that have been part of our discussion. The power of attorney, again, is this document that where you name an agent to manage your property during life. The person who is named in that role is named is an agent or an attorney, in fact, and the document is called a power of attorney. You can have a power of attorney that is durable, which means that it is effective now and is effective even if the person loses capacity. You could have a power of attorney that is springing, that is only effective if they lose capacity. But as you think about structuring this power of attorney, just remember how much power and control you're giving to this agent. This agent has the power to step into your shoes, to manage your accounts, to sell assets. So it might be very helpful to give that person the power to make gifts or other powers. But you might feel more comfortable giving that person more restricted control over the assets. Some clients prefer that type of springing power of attorney that is only effective once the person loses capacity. I worry about that a little bit. My thought is that giving someone this power of a power of attorney is just giving them a tremendous amount of access and control over your assets. And if you have any concerns about whether that person would exercise that control correctly, then maybe you're not naming the right person as agent. Just something for your consideration. Again, we talked before about healthcare decisions. And I mentioned how some of these documents are sort of combined or separated out depending on the state. But if we think about the functions of what these documents would do, the healthcare power of attorney or similar document would name an agent to make healthcare decisions on your behalf if you cannot make that decision. There would typically be default rules under state law of who makes those decisions if you don't have one of these. But again, it's really important that you are the one who says, this is the person who's going to make that decision. You could also have a document called a living will, where you determine what care you would want to receive or not want to receive. I had a lot of clients during COVID who started to give a lot of thought to whether they would want to be intubated. Other clients are giving a lot of thought to whether they would want to be in a coma for a period of time or donate their organs. All these are the sorts of things that you could include in a living will or an advance directive. You could include other decision points also. What I think these healthcare documents really provide is an opportunity for a discussion, for a conversation. And admittedly, it would be a very uncomfortable conversation with many family members. But you'd want to express to them why you're naming certain people as the ones to make these decisions and make sure that agent is comfortable making these decisions. And also what types of care you would or would not want to receive. Occasionally, we will see these stories in the news of someone who's in a coma and there's a fight over maybe whether to pull the plug or not, whether to continue care or not. What's interesting about those fights is that people tend to all say that they're acting based on that person's wishes. They would all say, I'm acting on behalf of Steve. I really think Steve would have wanted the plug pulled or not. It's very rare someone would say, oh, I know what Steve said, but I don't care what he said. I'm doing what I want to do. Well, if the person's intent is so important, let's make sure we really clarify that. Have an opportunity for a discussion so there's no surprises if you're in this situation and someone has to act under the advanced medical directive. Now, before we close and turn over to questions, I want to take a moment to talk about taxes. I mentioned a lot of clients are really focused on taxes and saving estate tax. And that can be a part of your estate plan, but I don't think it should be the only part. And frankly, I don't think it should be the most important part. There are three types of transfer taxes. There's estate tax for transfers upon death. There's gift tax for transfers during life. And there's also something, maybe my favorite, called the generation skipping transfer, GST tax. And that's a tax on transfers to grandchildren. We don't have time to go into a lot of detail about GST tax, but it's an interesting topic as you're thinking about benefiting further generations. And then various states have separate state taxes on transfers at death. I actually maintain a chart on all those different states for an organization I belong to called the American College of Trust and Estate Council. So there are a handful of states that have these types of transfers you might also want to navigate. Now, the good news is that there is an exemption from federal estate and gift tax. The estate tax applies to your gross estate. It applies to every type of asset that you can control upon your death. So it would apply to life insurance policies if you're able to control the beneficiaries. It would apply to 401ks and retirement accounts. It really applies to almost anything. It would apply to a revocable trust. So it's very broad in its application. But you may know that there now is a very high exemption from estate and gift tax. It's $10 million indexed for inflation. So as of 2023, that means that every one of you, as long as you're a U.S. citizen or resident, could pass $12.92 million to anyone in the world without paying any estate tax. Now, importantly, in 2026, that is reduced to $5 million indexed for inflation. There's a similar exemption from GST tax, and you might explore some strategies before 2026 to try to make use of that exemption. That's, again, maybe getting into the weeds. But how that exemption applies is that as you make gifts during life, you start to draw down on that exemption, currently $12.92 million. So as you draw down during life, making some of those gifts, you have less exemption that you can use upon your death. And then as it's adjusted for inflation, maybe the amount you have goes up. So you think about almost like a meter that might go up as there's an inflation adjustment and go down as you make gifts. Then upon your death, that's the amount you can pass free of any estate tax. Once you have used up all of your exemption, then that triggers estate tax at a whopping 40%. So it's something to take seriously, although again, I don't think it should be the only factor to consider here. There are a couple of other important exclusions from federal transfer tax. You can make a gift of $10,000 per recipient indexed for inflation. We call this an annual exclusion gift. That's indexed for inflation. And that's currently $17,000 per recipient for this year. And this is why, many, families with, sufficient resources or this type of intent, they would give out checks of $10,000 to $15,000 or $17,000 to various individuals. That's a way to transfer assets to those individuals without using any state tax exemption. Now, importantly, again, think about the goal. You might really want to avoid estate tax at your death, but just consider the fact that if you give someone $17,000 under this regime, well, they're the owners and they could spend it, maybe even spend it in a way you wouldn't have intended. So really look before you leap, before you start engaging in some of these types of transactions. Maybe that's just sort of a common refrain I'm discussing during this presentation. There's also an unlimited exclusion for medical expense and tuition. And I want to flag this because it requires some forethought. You can also pay as much tuition or as much healthcare expense on behalf of a third party as you want without using any of your gift or estate tax exemption. A lot of our clients really value education. So this might be a good way for them to serve their goals of benefiting education without using any gift or estate tax exemption. But importantly, you might want to let your family know of your plans so that you can pay the provider directly. And who knows, there might be a niece or nephew out there who really wants to go to law school, but feels like they can't afford it. Well, gosh, if they only knew that someone would be willing to make that distribution on their behalf, it might affect their plans. There's also an unlimited deduction from estate tax for a US citizen spouse, and also an unlimited amount that you can leave to charity. And before we leave this topic of taxes, I just want to flag this charitable deduction for a moment, because many clients come to me and they're really worried about estate tax. But as I talk more with them, they emphasize that they really want to benefit charities upon their death. Sometimes they say, I want to leave a huge amount of money to a charity. Well, at that point, I would say to them, you might not have an estate tax problem upon death, because if you leave all those funds to charity, there will be no estate tax due. So again, don't rush out with the idea of saving taxes if at the end of the day, we don't think there will be many taxes due. So again, consider all these factors as you think about what's the best strategy for you. We can also think a little bit about charitable planning. One benefit of charitable planning now is that it provides an income tax benefit. If you wait until death, that could save estate tax. But if you make gifts now, then it provides that income tax benefit. There's limits on how much you can deduct from your current income based on the types of charities that you benefit and based on the types of property. So as you're thinking about these types of charitable gifts, again, talk to your advisors, talk to your CPA, your investment advisor, a legal advisor, to make sure you're structuring it in the right way. Again, meet your goals and maybe have some tax planning benefits. I've flagged this issue of assignment of income also. Some clients try to give away property at the last moment before a sale, and the IRS has come back and said that they're treated as if they sold the property first, triggering huge amounts of income. So again, maybe this is just a cautionary tale to remind you to be careful and thoughtful about this type of planning. There's a couple of other different types of charitable vehicles that we could discuss at some point. Now, some questions that came up in these questions are, what about some special circumstances? I will say that foreign persons or assets or connections is sort of a reason to raise your hand and get very good advice. There are very complicated rules that apply if you have someone, maybe a spouse who's not a US citizen even, or if you have assets in another country, or if you have a family member in another country who's set up assets for the benefit of someone here. They're very complicated rules, and those rules can be very punitive if not followed. So you want to make sure that you're getting good advice. Some also asked about disabled individuals. There's ways to try to benefit individuals who have those types of special needs. The concern we have there is that those individuals might qualify for means-tested government benefits. Well, if you leave a lot of money to them outright, then the government's going to require them to use those funds before they can draw on those means-tested government benefits. But now there's a time you could set up, instead of having the assets go outright, maybe into a special type of trust called a special needs trust or supplemental needs trust that would provide that the individual can benefit from those assets, but also receive those means-tested government benefits. And again, something to be very careful about drafting so you reach your intended goal. We also had some questions about when's the best time to transfer a family business or a family vacation home. I think in the interest of time, I'm going to sort of wrap up here and pass over to Heather, and she can see what kind of questions have come in. Now, before I do that, here's some other considerations. Some of you have asked about what's a good time to think about estate planning. I sort of feel like, it's always a good time to think about estate planning. It's just a matter of what type of planning do you do, like young adults versus the older generations. So again, keep in mind all those types of issues as you think about your planning. All right, with that, Heather, I'll pass it to you.
So Steve, we have a number of questions here and we're probably not going to get to all of them. So I'm going to start with one that has come up a couple of times and may answer every single question there is. How do people find your podcast once removed?
Oh, it's on my McGuireWoods website. And it's on, YouTube and Spotify and all those sorts of things. So I guess my answer is I'm going to sound like a, like an old person who doesn't know much about podcasts and say that you have to just search for it online, but it's available on my website at McGuireWoods.com.
Okay, and we'll see if we can send a link to it in our follow-up email as well. So now to the real nuts and bolts questions. How long does the executor of an estate have to execute the provisions of a will?
Yeah, it's going to depend on different states' laws. A lot of people have horror stories of how it's taken years and years and an executor sort of isn't moving. Some states have some requirements of when an executor would have to act. I would say that the governing term here would be they have a reasonable time. And that means that they, don't have to rush in and distribute everything right away, but they also really shouldn't sit around forever. I like to talk about this as a very deliberate process. And that's something you can think about in your own estate planning of how do you sort of give your executor enough leeway so they don't feel pressure to distribute funds before they've identified the right types of creditors, right beneficiaries.
Great. So here's another one. What is the impact of adding my beneficiaries to the deed of my house during my lifetime? I still want to live in it until I die.
Yeah, so great question. And that might be an example of some estate planning where you're trying to do something very simple. Again, think about what the goal is. In many cases, clients would do that because they want to provide that at death, that residence passes to that individual as simply and easily as possible. And I love that. That's a great goal to have. I'm not sure if that's the best tool to add them to the deed. That requires filing a new deed. And also, it's hard to undo that deed if you want to take them off. Some states like Virginia have a transfer on death deed that's only effective upon death. So I guess be very thoughtful about this. Maybe there's a way to accomplish that you can also undo. I'd also be concerned that if you're adding them on the deed, that is a gift, and you might need to report that to the IRS. And again, it might be hard to undo if you decide you want to change your mind later.
Great, thank you. What is the difference between a durable power of attorney and a general power of attorney?
I would say the Venn diagram there doesn't completely sort of separate. A general power of attorney is a power of attorney that you give to someone to act on your behalf essentially for everything. The distinction I would make there is a general power of attorney versus a limited or a special power of attorney. You might have given your real estate attorney a limited power of attorney when you closed on your home, so they could go back behind you and sign documents you forgot to sign. But that doesn't give them the power over your bank accounts. A general power of attorney would give them the power over essentially everything. And then a durable power of attorney is one that is effective even if you lose capacity. And really, when we think about a power of attorney, we're trying to plan for a circumstance where you do lose capacity. So almost all the powers of attorneys we draft are durable.
Great. Can I use a trust to avoid the Secure Act law that requires a beneficiary to withdraw a retirement account in 10 years?
No, and I'll explain that in a moment. In fact, if you use, let me try to briefly summarize that. Under current law, if you leave an IRA to individuals who are essentially younger than you, then they have to withdraw that IRA within 10 years. It used to be the case you could stretch out over their lifetime, but with the new law called the Secure Act, which is a great acronym, they have to withdraw it over 10 years. You cannot use a trust to avoid that 10-year payout. In fact, if you have it payable to a trust, there's some risk that it would have to be paid out over 5 years and not the full 10. So no easy answer, no easy solution there. But if you are using trust and a retirement account, you want to talk to the right type of professional to make sure it's structured in the right way.
Great. I think we have time maybe for one more, maybe two. If I make my child a co-signer on my bank account, will my child be able to write checks on the account after I die? Or do I have to name the child as a joint owner?
So that's a great question and one that you should probably ask the bank. So I can give an answer that I think is correct, but the bank is the one who's going to have to honor those checks. And so you want to make sure that the bank is giving you that. sometimes when you're naming a cosigner, it is essentially naming an agent to act on your behalf individually. Well, if you name an agent, then upon your death, that agent loses their authority. So if the bank interprets that as just naming an agent, then that cosigner can no longer sign essentially on your behalf at your death. If you name them as the joint owner, well, maybe they receive all the funds after death, and then they can start to write the checks. The problem is now they might receive all those funds almost like a bequest. Well, what if you time it wrong, where that receives some big distribution from an IRA, and then suddenly that person receives a ton of money almost outside the estate plan? That could end up being really problematic. So again, maybe using that type of thing is a very laudable, try to simplify administrative steps, but make sure you really fold it into your overall estate plan.
Great. So I think that we're out of time, but Steve, I want to thank you so much for sharing your expertise with us. I also want to thank the UVA staff from the Office of Engagement for all they've done to facilitate this webinar. And then to our audience, thank you for signing in and participating and sending all of these great questions in. I hope everyone has a great day.